Exclusive possession of the marital home in a Florida divorce. There is no official law regarding changing the locks or keeping the house during a Florida divorce. The issue of whether one person has the right to change the locks during a divorce depends on who has exclusive possession of the marital home. Both parties to the divorce had access to the marital home because they both are residents of the home and probably both on the lease or the deed to the home. When one party files for divorce, there is not an immediate determination as to who gets to stay in the marital home. Typically, one party will move out because if you filed for divorce, you simply don't want to live with the other person any longer. Even though one party may have moved out of the home, that does not mean that the party has no right to return to the marital home. The party staying in the marital home obviously does not want to be disturbed by the opposing party bursting in at any moment. Domestic violence injunction or restraining order. If there has been an incidence of domestic violence between a married couple, the victim may request from the court a domestic violence or a restraining order. This injunction or restraining order almost always includes a clause providing the victim with exclusive possession of the marital residence. The award or distribution of the marital home can then be resolved in a subsequent divorce action. Exclusive possession of the marital home before the divorce is finalized. After a divorce is filed and before the divorce is finalized, exclusive possession of the marital home will be awarded via motion for exclusive use and possession of the marital residence. If the parties have children, the exclusive possession of the marital residence will usually be granted through a motion for temporary support, time-sharing, and other relief with dependent or minor children. So, if you get temporary custody of the children, you get temporary exclusive possession of the marital residence. If there are no children, a court is not likely to grant exclusive possession of a home if there has been no incidents of violence. Changing the locks to a marital home without a court order. I cannot advise you as to whether changing the locks during a divorce is forbidden or worthwhile. Your personal safety is your concern, and I won't fault anyone for taking safety precautions that do not hurt the other party. Should you decide to change the locks to the marital home without a court order granting you exclusive possession of the marital home, the following will happen. Your spouse will call the police. The police will tell both of you that this is a civil matter and that you should take this matter to divorce court. In the meantime, the police may allow your spouse to enter the house to collect his or her things. Your spouse may break into the house. This is not breaking and entering, however, because your spouse has the right to enter into their home unless there is a court order stating otherwise. Exclusive possession of the marital home when there are children. The Florida statutes provide that the marital home can be awarded to the parent who has the children if it is in the children's best interests to continue living in the home and that award is equitable. While this determines how the courts allocate the marital home in the final distribution of marital assets, it also provides direction as to who should hold the marital home in the interim stages of divorce. Courts can also award exclusive possession of a marital home as a substitute or supplement for child support. Exclusive possession of the marital home when there are no children. It's tough to ask the court to award the whole house to one person because the default in a contested divorce is to sell all of the marital assets and distribute the value of the assets equally. A marital home can be awarded exclusively if there is a special purpose. In a divorce where a house is awarded to one particular party, that award is the result of an agreement between the two parties whether it is a contested or uncontested divorce. If you truly want to keep the marital home or any other property, you are better off focusing on negotiating with your spouse in lieu of asking the court to award you exclusive possession of the home. To learn more about exclusive possession of a marital residence in a Florida divorce, contact Naples, Florida family law attorney Russell Knight for a free consultation.